Okay, let's call this interim meeting of the Senate Finance Appropriations General Government Subcommittee to order. Here we don't need to take roll, so we're going to kick right into presentations. We have, let's see, three presentations on the docket for today. Comp Board, Juvenile Court Fines and Fees, and Collective Bargaining. So first up, we have Compensation Board Staffing Standards. Robin DeSocio, step on up. Welcome to the General Government Sub. Yep.
All right, so good afternoon. I've been asked by staff to provide you all with an overview today, a bit of a background on information on Compensation Board staffing standards and how staffing needs are determined for Virginia's constitutional officers. So just kind of a bit of an overview. While the Compensation Board does handle a number of tasks and reporting processes, at its most basic, our mission is to provide state funding to support the operations of Virginia's constitutional officers. Our mission is set out in the Code of Virginia to fix and determine what constitutes a fair and reasonable budget for the participation of the Commonwealth toward the total cost of the office. And so Virginia's constitutional officers include the elected sheriff, Commonwealth's attorney, circuit court clerk, treasurer, and commissioner of the revenue. Along with these offices, we also fund regional jails in Virginia and appointed finance directors in 6 localities where there is not an elected treasurer and commissioner. Our daily activities are based around establishing budgets for the operation of each office, where the locality appropriates the funds that we budget along with any local funds, and then the Compensation Board reimburses the locality on a monthly basis as expenses are incurred by the constitutional offices. But so the key points to our mission are that we must allocate funds in a manner that is fair and reasonable, meaning we treat everyone the same using objective criteria, and that we allocate the state's share, so that which is appropriated by the legislature and is not necessarily intended to cover all expenses for operating these offices. I've included a chart up here that identifies the total appropriation to the Compensation Board for constitutional officers, or rather the split of that agency appropriation. In total, the Appropriation Act includes about $939 million in fiscal year 25 across the officer programs. The majority of that, of course, goes to sheriffs and regional jails. They are the largest group of offices, and then the other offices slightly less. There are 15,000 individual positions that are allocated across the 650 constitutional offices that we fund, and 99% of the funding that we appropriate, that you all appropriate in the specific officer programs is allocated for salaries for these positions. So very little funding for anything beyond just paying the salaries of individuals that work in these offices. So speaking to the fair and reasonable portion of our mission, the Compensation Board has established workload-based staffing standards for the determination of position needs and for the allocation of the positions once they're appropriated for the constitutional offices. And we've been doing that since the early 1990s. When we develop staffing standards, the development of those standards is a collaborative process between the Compensation Board and the constitutional officer groups. We typically work with committees of officers that are representative of their body overall for each respective constitutional officer association. Now, while some of the staffing standard components are directly out of statute or Appropriation Act language, the existence, the development, and the use of staffing standards to objectively allocate funding is required by the Appropriation Act. Formal approval of staffing standards is, however, by Compensation Board policy, and the collaborative process allows kind of the workload experts in the field to be engaged in the process while the board makes sure that relevant factors are included and in keeping with directives towards appropriateness of what the Commonwealth is funding. So I'll go over each group just to provide a little bit of information about how they all work. Staffing standards for sheriffs are defined through a combination of requirements established in the Code and in the Appropriation Act, as well as by Compensation Board policy. And there are separate standards for each sheriff's office responsibility carried out by their sworn deputies. So there are 3 functions, essentially, overall, that sheriffs perform. Law enforcement is provided by sheriffs in counties primary law enforcement, and so the standard for law enforcement deputies is based on statutory language. It provides the allocation of one deputy sheriff for every 1,500 people in the locality population, and again, this is in counties where the sheriff is the provider of primary law enforcement. So most counties in Virginia, no cities in Virginia, and a handful of the larger counties in Virginia do not have the sheriff providing their primary law enforcement. They instead have a police department. Deputy position funding for law enforcement is currently short under the staffing standards by about 371 positions statewide in fiscal year 25. We currently have 1,900 positions that are allocated, so 1,900 allocated and 371 short, estimated to go to 381 in fiscal year 26 based on population changes. So the current deputy to population ratio averages statewide about 1 to 1,730 as opposed to 1 to 1,500. The growth in that growth in number of positions allocated for law enforcement was last funded in fiscal year 2008. Now, for some of their other responsibilities, court security and service of civil process is a responsibility that all sheriff's offices have. The standard for allocating those positions is based in Appropriation Act language as well as time study for some of those components. We base the staffing on court days and civil papers that they serve. Court deputies are provided only for security in the courtroom when court is in session. But they provide it for all three courts, Circuit, General District, and JNDR. But they do not, we do not provide, or the Commonwealth does not provide staffing to support the entire courthouse security, including the courthouse entrances. So there's specific Appropriation Act language that precludes funding from the Compensation Board for courthouse entrances, primarily as courthouses are built and operated by the local government, so they make decisions about which offices are housed in that courthouse, how many entrances there are, those types of considerations, and so the local government has that responsibility for overall security of the courthouse. There is an optional courthouse security fee in the code that localities can adopt in order to generate revenue to provide for those local courthouse security requirements. And then deputies for service of civil process are based upon numbers of papers that they receive for service and a time study that was conducted to determine how the number of papers that could be served per hour based upon the size of the locality was determined. So there are a couple of other additional considerations that go into this, what we call court services staffing standard. We also include some consideration for behavioral health transportation and also for extraditions. This is the only type of deputy that all offices, all sheriff's offices have. And so regardless of whether they have law enforcement or court services or a jail, they are sometimes called on to deal with behavioral health transportation and extraditions. So we put some hourly time into the staffing standard for those responsibilities in with court services. And then finally, correctional deputies and regional jail officers. The staffing is based upon primarily language in the Appropriation Act. Ultimately, staffing when a facility is newly constructed or when a facility is expanded is based upon an individual assessment of what the jail needs to operate in terms of its duty post, type of supervision style, that type of thing. So there are individual assessments for each jail, and then the Appropriation Act provides a maximum of 1 deputy for every 3 beds of rated operating capacity. And then there's also a standard that would provide 1 deputy for every 5 inmates of average daily population that exceeds that capacity. So right now there are 7,064 deputy and regional jail officer positions that are currently allocated across the jails in Virginia. And then there are additional standards that also provide for other positions in the jail, such as administrative support, food services, medical services, classification, and records management.
Mr. Associate, do you want to take questions by section, or do you prefer to wait till the end? Or what?
Mr. Chairman, I'm happy to go with your preference. If by section is better for the members, I'm happy to do that.
Anybody else have questions at this point? You do?
Not yet.
Okay, I have a couple questions.
Certainly.
Why don't we just go at it that way for now? So some sheriff's offices, at least the ones I'm familiar with, I've never represented, well, actually, I did represent a law enforcement sheriff county briefly when I represented Stafford, but Prince William and Fairfax don't do law enforcement primarily. They can, but they don't. So the sheriff's offices I'm most familiar with have other programs which I would say sort of fall outside of what you've talked about. For example, I think in Fairfax there's like some kind of a mental health program I think the sheriff does there and provides some additional sort of supplemental services. How do you all look at sort of, how do you all determine what a core competency for an office is versus something that you don't want to fund if the sheriff wants to do it?
Well, most of the standards that we have it's not really been our decision, the compensation board's decision over time. These primary duties as spelled out in code are what we provide funding for and what we have. There are a lot of the standards for sheriffs are in the code or in the Appropriation Act. So to some degree, that would be the legislature's decision. There are a lot of funding sources through DCJS that are grant-funded programs, and so a lot of the resources that sheriff's offices and regional jails receive for some of these specialty programs run through Department of Criminal Justice Services as opposed to through the Compensation Board. We provide this kind of base level of support, but there are a lot of grant programs that fund those items.
Two of the questions I had, do you all factor language issues into your allocations? So for example, I know that in many of my locality, or my one locality remaining, my old locality that two localities Pike now has, there's a lot of people that come through the prisons that don't speak English. And I assume that creates some additional staffing needs within the jails. I mean, how do you account for that? And then my other question is, I know our localities supplement funding significantly, and including funding additional positions. Mm-hmm. And every once in a while, you all provide additional positions, and the localities seem to always want to take their money back, and I'd like them to keep putting it in instead of taking it back. I'm just curious how you all take that into account or balance it or whatever. Those two things are on my mind.
So to your first question, your second question, we don't necessarily consider the local funding that is provided into any of the formulas that we calculate. So we don't have, for example, a Northern Virginia pay differential. Some other state agencies, I think the courts may have a Northern Virginia differential. I know that Indigent Defense has a Northern Virginia pay differential. State Police has a Northern Virginia pay differential. We do not. And so in those cases, yes, for certain, there are a lot more local funds coming in through Northern Virginia, Tidewater, even Central Virginia localities, mostly to address salary issues. And some of these other issues you spoke specifically about translation services. We do not have any staffing that is allocated for that purpose. We have a kind of generic category that provides some medical services, some classification, some treatment, some records management in one of the types of staff positions that we fund. We actually fund those positions at 2/3, and the local government has a 1/3 match. But we don't provide for those language interpretation interpretation services. We do, however, produce a jail cost report, and I'm not sure, Mr. Chairman, whether you've ever seen it, but it is an accounting of all costs, all expenses and revenues in every jail in Virginia. So it identifies where all of their revenues are coming from, whether it's state funding, local funding, federal funding, work release, things like that. So it accounts for all of the revenues that are coming in and all of the expenses that jails are incurring. I'm not sure off the top of my head. I don't think there is a specific line item for translation. But definitely if you're dealing with those costs in the jail, they're going to be accounted for in that report. And it really shows a broad range of, what each locality is paying to support the cost of operation of its jail over and above what the Commonwealth is funding.
Okay, so you don't require localities to leave their money in when you, for example, when you allocate an additional 5 positions and a locality tries to take those 5 positions, the money they've been providing back, you don't take that into account. You guys don't require a hold harmless when you allocate a position. You don't.
There's
You don't
not.
allocate more positions, for example, to Pillion's district because his localities aren't gonna pull their money back. Like, for example, Northern Virginia locality might, who's been putting a lot of local money in.
Right. Mr. Chairman, I know that a lot of the constitutional officers definitely want language in the act that would support that. Right now, there's very little language in the act or very little directive to local governments that says that they have to maintain their local funding if the Commonwealth provides more.
Okay. You answered the question.
Okay.
Last question I have on this. Virginia Beach, I know, has a program that's been around for about 12 years now where their sheriff has created a store where if you buy food through their store, hamburgers, pizzas, the weekender kit, underwear, all kinds of stuff, those profits the sheriff gets to keep and spend themselves instead of it going into the general fund, and the sheriff can use it for whatever reason they want. Not every sheriff in the state has done that. I don't think many have. Do you all take those kinds of resources into account in your jail report or whatever you call it, or how are those kinds of revenues determined?
Mr. Chairman, that information would be in the report. I'd have to go and see, we might have to delve into some of the details behind the report to see if we can parse that out. We definitely have information about canteen, telephone commissions, things like that in the report. So I'd be happy to provide that. We can talk about it further if you would like, Mr. Chairman. But I know there was a legislative change this past session to limit some of that.
But you all don't take it into account.
We don't take it into account as far as how we fund the jails. But as far as our annual jail cost report that identifies all of the revenues and expenses in the jail, we would have accounting for it there.
All right. Let's talk about Commonwealth attorneys. Unless there's other questions about any of that. Nope.
Moving on to Commonwealth's attorneys. Excuse me, there are separate staffing standards for Commonwealth's attorneys' offices, identifying the need for attorney positions separately from administrative support staff, so separate standards for administrative and paralegals that are different from the standards for attorneys. Just kind of real briefly, Commonwealth funding for assistant Commonwealth's attorneys is based on felony caseload and does exclude discretionary misdemeanor prosecution. The staffing standards are based, primarily on what the code requires Commonwealth's attorneys to do, and where certain misdemeanor prosecutions are considered discretionary, we do not have funding appropriated to support those costs of staffing in Commonwealth's attorneys' offices. Just to speak briefly on administrative support, we do have funding for administrative and paralegal positions, and the staffing standard for those positions is based upon a ratio of 1 administrative position, so meaning a secretarial or an administrative assistant position, for every 2 attorney positions that are due in the office, so not necessarily the positions they have, but the positions that are standard for attorneys would indicate they need to operate their office, and then 1 paralegal position for every 4 attorney positions that are due in the office. So it's a pretty straightforward standard. Staffing standards for assistant Commonwealth's attorneys, as you know, were recently updated through an extensive 2-year workload and time study conducted by a contract with the National Center for State Courts. In fiscal year 25, there was new funding appropriated by the General Assembly and provided 29 new assistant Commonwealth's attorney positions and 18 paralegal positions to be allocated across offices in Virginia. There are currently 728 attorney positions allocated, including the 120 elected Commonwealth's attorneys and 608 assistant Commonwealth's attorneys. And then attorney position funding is currently short by about 235 additional positions in fiscal year 25 and fiscal year 26. And again, that excludes any discretionary misdemeanor workload, so that's based solely on felonies. There are also currently 496 administrative support and paralegal positions allocated statewide. There is a shortfall as well according to the standards for the number of positions that would be due. Administrative position funding is currently short by about 133 positions, and paralegal position funding is currently short by about 115 additional positions in fiscal year 25 and 26. So talking a little bit about the workload time study, the previous standards for attorneys were based on more generic measures of relative workload. So we looked at a couple of different factors, including counts of defendants in felony cases and counts of final sentencing events post-conviction. Those were not, necessarily direct accountants for everything that they do in their office, but they were relative measures that could then be compared across offices. It definitely had its weaknesses. As far as things like looking at the different types of cases and different mechanisms of handling those cases. There was some language that was approved several years ago to initiate the time study with the National Center for State Courts. The Compensation Board had actually begun before that talking about the need to make some changes because we were seeing activities appear to change in different localities in a way that didn't really make a lot of sense and was clearly not accounting for everything that they were doing. So it was good timing for this study. 95% of all elected and assistant Commonwealth attorneys participated in the data collection period, gathering all of the time and activities over 13 weeks. So it was a really extensive time period for study. It included all of their time, both in the office and if they were working on weekends, catching up. So the study also included extensive participation by elected and assistant Commonwealth attorneys in surveys, advisory groups, focus groups, and quality adjustment groups. So we went through an extensive process, very similar to a presentation you had by the National Center about judicial workload. Some of the same processes were used in going through and reviewing the data, making quality adjustments, that type of thing. The new standards for attorneys are based on extensive weighted caseload data across all courts, including problem-solving, specialty court dockets, drug courts, behavioral health, veterans courts, but also include time factors to account for non-court and non-case related specific activities as well. So including factors and time for diversion, body-worn camera review, FOIA, expungement, rights restoration, and other civil statutory responsibilities that Commonwealth attorneys have. Other innovations in the process include extensive case filings analysis to produce defendant-based cases for weighting according to most serious offense. And ultimately, the workload study provides a separate methodology to account for misdemeanor work to inform on the staff needs in that area. However, the Compensation Board staffing standards do not incorporate this work for Commonwealth funding. Mr. Chairman, I'd be happy to answer your questions.
Senator Evan has a question.
Yeah, thank you, Mr. Chairman. I have two questions. I know in Northern Virginia we supplement our Commonwealth's attorneys' pay with a pay differential because you can't find people to work for the amount the state offers, at least in my locality. And there was, at one point, we had a bill a few years ago to provide for a pay differential for public defenders. Does the state pay for the public defender as well as the Commonwealth's attorney?
Yes, so Mr. Chairman, Senator, actually the Indigent Defense Commission and public defenders are state employees, and so they do have a Northern Virginia differential. Constitutional officers are considered state-supported local employees, so they're technically local employees that the Commonwealth contributes to, and we do not have a Northern Virginia differential for the salaries that we establish. So indeed, there certainly would be recruitment issues in Northern Virginia and other areas of the Commonwealth with respect to the salaries that we provide. There have been significant increases for assistant Commonwealth attorneys over the last year based upon actions that were approved by the legislature. But we do not provide, the changes that occurred in the past year aligned the Commonwealth-funded salaries for indigent defense and Commonwealth and assistant Commonwealth attorneys. That may get to your
Go ahead, Senator Evan.
To follow up, has there been a proposal in recent years to provide a differential for the Commonwealth's attorneys in harder to staff or more expensive to staff areas?
Senator, I have not heard of any attempts to do that in recent years.
Okay, thank you.
I have a couple questions.
Mr.
So
Chairman.
I saw here that, I'm trying to understand, you said that the funding for CAs is based on felony caseload. I know you did your whole study. Is felony caseload still the primary variable? Yes or no?
Mr. Chairman, case filings are used as the
Okay.
data source.
Got it. So, case filings, we having the same fight over the weighted caseload study over judges right now, because case filings is a statistic that can be manipulated. And so that in some localities, the Commonwealth attorney could indict 20 felonies under one indictment and get 20 filings, whereas they might file one indictment with 20 felonies in it. But it looks very differently numerically for purposes of determining staffing. And I know one of the reasons you did the study was to get away from Commonwealth attorneys manipulating the data to justify higher staffing totals. So what are you doing now?
So, Mr. Chairman, I have an answer for that. When we went through the study, there was extensive work done on the part of staff at the Supreme Court to help us pull the data together in a way that would not allow for that. So when you talk about case filings, it's not on a defendant basis. So exactly what you're speaking of, if you had one offense charged and then a number of trailing charges in one locality, but another locality that only had one or two trailing charges on essentially the same type of case, what the data analysts were able to do with the case filings data is consolidate all of that into a defendant-based statistic. So there was extensive work to talk about kind of timelines and how to do that, because the data in the Supreme Court system doesn't track the cases that way, but we were able to pull all of the raw data and consolidate them to a defendant base. So if you had those multiple trailing charges or just one or two, it could all be consolidated into one case event under the most serious offense.
Okay, so it's fair then to say that unlike the old system where staffing was primarily determined by the number of felonies indicted and the number of felony convictions obtained, you all have now adopted what you view as a sort of more robust standard to try to reflect actual workload. Is that a
Mr.
fair
Chairman,
statement?
that's a fair statement.
Okay, one other question. Commonwealth attorneys' offices have to do other responsibilities that are both statutory and some discretionary. And am I also correct that you all, as part of your determining your staffing standards, don't consider expungement volume, whether or not Commonwealth attorneys have innocence units, the number of parole requests or reviews they have to do, whether Commonwealth attorneys' offices use their authority to prosecute or bring civil actions, for example, under the Consumer Protection Act, or there's a whole bunch of different civil authorities we give them, whether they do their response times on, for example, Freedom of Information Act requests or other kinds of, again, these are things they're authorized to do by statute,
Right.
but not everybody does. That's not included in any of your weighting, right?
That's not correct, Mr. Chairman.
Okay.
So while we are counting case filings as the means of calculating a staffing standard across all offices, the weights that go into each of the case types incorporate all of that work in it. So when we did, when the National Center, let's be fair, we didn't do that work. The National Center ran the time study, and all of the attorneys reported all of their time every single day for 13 weeks, whether it was in the office, at home, and there were a multitude of categories where they were checking where they were spending their time and how much time. So it included all of those things that you're referring to. And the way that that gets incorporated into the standard is they're identifying cases or non-case items that they're working on, and then those individual factors that also go into that work. And so when they weight the cases, it's considering the time associated with those types of events. So I'm probably not as articulate on this as the staff from the National Center for State Courts, but they did incorporate all of that, whether they were doing, body-worn camera review or all of these other things.
Well, let me put it this way. There's some offices in Northern Virginia I know that have innocence units. They're probably the only ones in the state. There might be one other one outside Northern Virginia. There's other ones that are doing civil prosecutions. There's other ones that are doing wage theft, or maybe once in a while they do it. Is it fair to say that if those offices choose to do that, the amount of effort that they choose to put into that doesn't really get funded by the state because it gets watered down because the other 125 offices around the state aren't doing it at all, so that they don't really get state allocation money for that, right?
Mr. Chairman, I don't think anything is going to be perfect unless we capture every single minute, every year of everything that they're doing. And not at all trying to be flippant about that, but I think that we have done a really good job of coming up with a methodology that factors all of these things in. Nothing's going to be perfect. But I think that it is inclusive of a lot of that extra time. There are specific, places in the state that were starting to suffer under the old methodology because it wasn't picking up those other things, and now it does. In fact, in Fairfax County, we had to do some specific manipulation because their court data doesn't come in through the circuit court the same way that everybody else does. And so we're physically getting data from them to make sure their direct indictments are counted properly. The general district warrants, everything is flowing upward. So I think we have a really good picture now, Mr. Chairman.
Okay. Any other questions about CAs? We're going to move on to clerks and commissioners of revenue and treasurers, finance directors.
Thank you, Mr. Chairman.
Yeah.
All right, so staffing standards for deputy clerks and support staff and circuit court clerks' offices were developed and approved by the Compensation Board in conjunction with a committee of clerks over 15 years ago, but there have been periodic reviews in between to look at workload definitions and that type of thing. Circuit court clerks are, sort of different from sheriffs and Commonwealth's attorneys in that a lot of their workload is very transactional. They're responsible not only for the administration of the court and court-related workload, but they also have hundreds of responsibilities defined in the code. Thus, their transactional workload is also an important component to their staffing standards. So their workload includes weighted workload elements related to both criminal and civil cases, but also transactions that impact land records, whether we're talking about wills and estates, deeds of trust, judgments, financing statements, processing and handling of marriage licenses, game licenses, fictitious names, they qualify notaries, they process concealed handgun permits, they handle restitution, and a lot of incoming fines and costs. So their workload and staffing standards is very transactional. They count those transactions every year and report them to the Compensation Board on an annual basis. With all of our standards, use a 3-year weighted average. So we look over periods of time to pick up differences as they occur from year to year, but have kind of a 3-year rolling average so that you mitigate any one-time aberrations. There are currently 1,122 elected circuit court clerk and deputy positions allocated. Under the current deputy clerk staffing standards methodology, funding is short by about 37 additional positions. However, we are getting ready to launch into a new time study for these offices as well. Pursuant to language and funding approved by the 2024 special session of the legislature, we are contracting with the National Center for State Courts to conduct a workload and time study for circuit court clerks' offices over the next year. We're planning underway. We're establishing the necessary steering and advisory committees for this and completing the contract with the National Center. I know one of the things that of course is of interest in this study is a review of the impacts under the legislation related to sealing and expungement. And so we're hoping to work with the Clerks National Center as well as the Crime Commission on kind of an initial review of what we think some of the impact of that might be. So that will be part of this, and then we'll look to a broad time study similar to that we did with Commonwealth's attorneys in the spring. Mr. Chairman, do you have any questions about circuit court clerks?
You answered my question with the ceiling paragraph there. Anybody else? Nope. Okay, commissioners of revenue and treasurers and finance directors.
Thank you, Mr. Chairman. The staffing standards for deputy commissioners of the revenue and support staff in those offices were developed and approved by the Compensation Board in conjunction with a committee of commissioners over 10 years ago. They also do periodic reviews and updates of workload items and definitions as their work changes. The commissioners of the revenue are the chief tax assessing officers in their localities, so they administer assessments for businesses and individuals. And so the staffing standards for these offices reflect those types of transactions. They are based on weighted workload transactions in the areas of real estate and personal property tax assessment, business license fees, machinery and tools, merchants capital, excise taxes, tax relief programs, and assisting citizens to the extent that they still do with state income taxes, and some of them also provide DMV services. So again, with these offices, they count these transactional items every year, and they report them to us, and we run a 3-year average. There are currently 850 elected commissioner of the revenue and deputy positions that are allocated statewide. Under the deputy commissioner staffing standards methodology, their position funding is short by 156 additional positions. Mr. Chairman, do you all have any questions related to the commissioners of the revenue?
Senator Eben and I did, but I think you might answer it in the last paragraph on page 8 of your next slide, where you basically say that if you don't have a commissioner of revenue or a treasurer, you guys provide funding to a director of finance
Mr. Chairman,
instead.
that's
So like
correct.
that'd be like Fairfax, Prince William, Alexandria, some other places.
Henrico,
Okay.
correct. Richmond City.
Okay.
Richmond City is a little bit different.
All
Yes,
right.
sir.
Cool. Okay. Why don't we move on to treasurers and finance directors?
Thank you, Mr. Chairman. Moving on to treasurers and finance directors, the staffing standards for these offices as well were developed and approved by the compensation board. The treasurers have been reviewing potential changes in the past year, and they are looking at potentially a renewed time study. Treasurers as well in the finance arena, they are the chief financial officers in their localities, so they collect taxes and local fees and process payments on behalf of their localities. The staffing standards for these offices, again, are based on weighted workload transactions in the areas of real estate and personal property tax collections, license tax collections, permit fees. They do some financial management, including investment management for their localities, and some state income tax and DMV processing as well. There are currently 853 elected treasurers and deputy treasurers statewide, and currently short about 146 positions. And indeed, in 6 offices, there is an appointed director of finance that handles all of the duties of both the treasurer and the commissioner of the revenue, where those offices are not present. And the staffing standards are combined for those offices. We combine the standards of both the treasurer and the commissioner to count all of those workload transactions and determine a staffing need for those offices. There are 276 positions across those 6 offices, and they are short under the current methodologies by about 101 positions.
I think Senator Eben has another question.
Yeah, when you say that that staffing is short by 146 positions or 101 in the people who have finance directors, do we know, do they typically not fund them because the state hasn't funded them, or do they pay for them locally?
Mr. Chairman, Senator, they're short on what we put together in terms of the staffing methodology. So there is certainly a likelihood that there are locally funded positions that are filling in some of those gaps. The standards that we establish don't actually incorporate every single thing that they do if they are doing things that are completely at the locality's discretion. So there's some mixture of things that are considered state mandated functions that we would incorporate into our methodology for determining the number of positions that we would ask the Commonwealth to allocate. And then there are likely separate transactions, workload items that they handle in their offices that we don't consider. And the local government may be funding those. The local government may also be funding the difference between what our methodology says should be provided and what's actually been appropriated.
Thank you.
So when we decide to put a slug of new money into any of these areas, whether it's for CAs or clerks or sheriffs, how do you all decide where to send that money to the different localities?
Mr. Chairman, and of course the Commonwealth's attorneys' positions that were allocated this last year are a good example. So in addition to having a methodology that says X number of positions are due, certainly often not all of those positions are funded. And so we prioritize in what we call a priority, or we rank them in what we call percentage of need order. So if an office has 10 positions and is due 1 position, that's 10% of need. If an office has 1 position and is due 1 position, that's 100% of need. Those smaller offices are going to pull up to the top, but it really depends on where the need has not been met and how the standards, identify how many positions are due. And so a really good example would be the recent allocation of positions in Commonwealth's attorney's offices. With the change in the methodology, there were some offices where their workload, just due to different handling and different criteria or different weighting of cases, weren't necessarily at the top of the list who came up to the top of the list, because even though they're large offices, they had a large number of positions that were due. So using that percentage of need still put them at the top of the list. The compensation board does also require that the office makes the request. We do an annual budget request process with the constitutional officers every year in January, and the offices have places to make the request for additional staff that they need in their offices. Sometimes funds are allocated or appropriated and an office says, I don't need it, or I don't have a place to put this person, or I don't want it for some reason. So if they don't make the request, they're not going to necessarily be allocated that position. Even if they're at the top of the list, they make that determination themselves.
So suppose an office is allocated position and funding by you all, and they don't fill the position. So I know there's been a lot of vacancies around the state. Mm-hmm. Does the Commonwealth, does the constitutional officer get to keep that cash and decide to spend how themselves, or does it revert to you all to reallocate?
Mr. Chairman, there are ways that offices can use that savings if they have a vacancy and they're having a difficult time filling it. It accumulates some one-time savings that we call, vacancy savings. They can use that money. They can put it in what we call an hourly wage category, where they might need to hire 2 part-time people because they can't find a full-time person, and so they can pay for it that way. They might, on a one-time basis, be able to use it for an equipment need or some other need.
Okay, but they can't hoard cash by not filling positions. Your money, the money you allocate to them, they can't just hoard it over time.
Mr. Chairman, their general fund dollars, they revert to the general fund at the end of the fiscal year, so there's
use
not
it
really
or lose it.
a way to, well, yeah, I mean, it's part of their budget
Okay.
the next year, so they can fill the position, Mr.
Okay.
Chairman.
Thanks. Any other questions? Nope. Okay. Thank you for answering our questions and presenting.
Thank you for the opportunity to
Yep.
speak with you today. Thank you.
Great. All right, next up, we have juvenile court fines and fees, fiscal impact discussion. I think it was legislation by Senator Aird regarding waiving all of juvenile court fines and fees.
Yep. Thank you, Mr. Chairman. So we'll start with a little bit of background. So as you just said, Senate Bill 41 in the 2024 session was continued into 2025 by the Senate Finance and Appropriations Committee. This subcommittee recommended that SFAC staff further examine the fiscal impact, along with OES, Office of the Executive Secretary of the Supreme Court, which helped us a ton, and then Crime Commission staff, who helped us with some research on other states. So as you said, the Senate bill generally just prohibits the courts from imposing fines, costs, and fees against juveniles in certain circumstances, and so we're going to walk through the fiscal impacts. So first, we're going to start with the summary of the legislation. I'll just briefly walk through this, since we'll touch on parts of it throughout the presentation, but there's a number of provisions that the bill touches. For one, it prohibits courts from imposing fines, fees, or costs against any juvenile charged with a criminal offense or a delinquent act, except for certain driving-related offenses. I'll just pause here and say that whenever I use the term juvenile throughout this presentation in the bill, generally that's going to refer also to their parents or persons responsible for their care. So it's really their family who they're not imposing the cost on. The bill also, for all juveniles under the applicable court's jurisdiction, so not just delinquency matters that we just referenced, prohibits the imposition of fees or costs for certain investigations, drug screenings, and other services. The bill removes the court's authority to assess costs paid by the state for court-appointed counsel and public defenders in most juvenile cases. It prohibits support payments to the Department of Social Services for parents, guardians, and trustees for, again, just juveniles in delinquency proceedings that result in certain types of out-of-home placements. And the bill also prohibits the assessment of some civil penalties, as well as fines, fees, and costs for certain alcohol and nicotine-related offenses. I'll just say here, we don't really get into the civil penalties in this presentation because the bill only enumerated 3. 2 of them are generally not collected under current law, and the 3rd was removed in this past session. A prohibition or a penalty for minors who possess certain nicotine-related products was removed. So
Quick question. Did the bill also prohibit the ordering a juvenile to pay restitution?
Mr. Chairman, no, and I'll have Taylor second me on this. The bill does not address restitution, only costs, fines, and fees. And Taylor's nodding, so yes, no restitution.
Great. Okay, thanks, Katie.
So in general, in this presentation, you'll see I kind of divided the fiscal impacts into two categories. One is much easier to measure. We're going to start with that one, and the second gets a little more complicated. So this first section is amounts collected and assessed by the court. That's primarily what you saw in the fiscal impact statement during session. So unfortunately, we don't really know how much or how many costs, fines, and fees were collected from juveniles that would be impacted by this legislation. The reason we do know how many were assessed, and so the reason for that, and you're going to see this throughout the presentation, is that OES, Office of the Executive Secretary, essentially has two systems. The assessment system has offense-related data, so if you make a policy change that is specific to certain offenses, you can track it in the assessment system, but then you basically have to assume a collection rate to know how much you actually collected from those assessments. So what we're looking at right here, this about $600,000 per year, that's specifically assessments, not necessarily how much was collected, and that includes about $230,000 from JDR courts and about $365,000 from circuit court clerks. Just so you kind of know, again, what you're looking at, the offenses covered by the bill and therefore reflected here primarily include delinquency matters or in circuit court criminal cases. For most of the provisions, the bill does not impact those with traffic infractions and also certain criminal traffic cases, so especially underage DUI. So those would continue to be collected for the most part after this bill, and they're not reflected in these payments that would essentially, these assessments would basically no longer occur if the bill passed.
Sorry, Katie. So I don't understand why was traffic DUI excluded?
Mr. Chairman, that was just pursuant to the bill, and I did go back and watch the Courts of Justice. I think the way it was introduced, it didn't exclude those. Then I believe Senator Ayer proposed an amendment that would have excluded traffic infractions, and then the Courts of Justice substitute excluded those additional criminal traffic infractions like DUI, and I believe there's one other. So essentially it was added in the Courts of Justice substitute.
Okay, but you don't have any idea how much is traffic, and I'm sure DUI is puny, but how much is traffic versus the rest in terms of?
Mr. Chairman, I don't have the top of my head, but I could pull that easily using the court's data to kind of see if we incorporated traffic infractions, how much would that change it? If we incorporated those other criminal DUI type stuff, how much would that change it? So not at the top of my head, but that's something that could be pulled.
Okay, all right.
Oh, and just a general note that Fairfax doesn't participate in circuit court systems and OES, so they're not going to be reflected in this estimate right here.
So we are 17% low unless juvenile crime in Fairfax is inordinately low, or its Commonwealth attorney doesn't prosecute as aggressively as other jurisdictions, maybe.
Sure.
Okay.
I believe you.
All right.
So now those were the assessments. Based on those assessments, essentially best estimate is about a $360,000 per year was actually collected. Again, we can't look exactly at the collections, but in lieu of knowing the actual collection rate for these offenses, a collection rate of 60% is assumed. That's essentially just based on all of the collection rate of all cases in JDR court. So that's also going to loop in things like child dependency cases, children in need of services. Adults can obviously go to JDR court depending on who the victim is, domestic relations. So, best guess we have is looking at all of the cases in JDR court, what's the collection rate, and that was the 60% that's assumed. And so that's how you get to this about $360,000 per year that we're estimating would no longer be collected by the courts under the bill.
So I understand the 360 doesn't include Fairfax, but you're saying it also includes fees that are assessed against parents in termination of parental rights cases and other things. I mean, domestic violence cases and.
So, Mr. Chairman, essentially those cases are reflected in the assumption of 60%. So the 60% is then applied to the correct assessment amount. The assessment amount is specific to the fees in the bill. It's just basically the collection rate we're assuming is kind of a broader group that we're pulling. So like if for some reason those cases are collecting more or less than juvenile delinquency cases, we wouldn't know. That might be skewing it, but the amount is still, we're applying it to the correct cases. Just the assumption that we're making is based on a broader
So
group.
603 plus Fairfax is the total amount of fines and fees assessed against juvenile delinquents in criminal cases.
Subject to that would be impacted by this bill
got it.
specifically. So this next slide basically talks about where they go. Again, we don't really have specific data. What I basically did was look at all of the JDR and circuit court. Where does that money go? We can track it by that group, and just went through and said which of these might be able to be collected against the juvenile delinquent. And so looking at that, and again, this is really a breakdown of where that $360,000-ish per year would go. It's not on top of that. A majority of that would likely come from the general fund, and then a portion would also come from the literary fund, because as you know, all criminal fines by constitution have to go into the literary fund. There are kind of these other funds that are impacted. So a lot of these are being brought into this because they're part of some of the fixed fees in circuit court. So if a juvenile was transferred to circuit court and tried as an adult, a portion of their fixed fee might go to some of these other funds, but the total amount impacted, again, is that estimated 360 plus Fairfax, and the majority would likely be general fund. Moving to the next slide. So this is just a note. This is included in those general fund payments that we just referenced. But under current law, non-indigent families in juvenile court are assessed amounts paid by the state for court-appointed counsel based on ability to pay. Mr. Chairman.
Sorry, on the 360 plus Fairfax number, do you have any sense of what the average fine is? I mean, are we talking like 25 bucks a kid? Are we talking 100 bucks a kid, 200 bucks a kid, 1,000 a kid? I don't understand. I'm sure it's not 1,000, but.
Mr. Chairman, so I could maybe do a proxy estimate. I will say that OES tracks things based on charges. So I could try to do something that basically, use an average of charges turned into defendant and then divided it out. But it's not going to be exact because we don't really know how many juveniles are in the system. We just know how many juvenile charges are in the system. But I can certainly pull some kind of proxy for you. And I'll also turn to OES if they have any thoughts on kind of the average per juvenile. Want me to keep going while they confer?
Sure. I just think in terms of evaluating the policy choice here, it might make sense to understand some offenses which might be more poverty related versus ones that are other behavior related, whatever. I mean, there might be different ways to slice this, but instead of just having a one size fits all over-inclusive policy decision, and I'm just trying to get a sense of what we're talking about.
Good afternoon, Mr. Chairman, members of the committee. Alyssa Patton with the Office of the Executive Secretary. We were talking amongst ourselves. We'd be happy to work with Katie on trying to come up with an analysis of what the average amount is. Certainly when we're talking about juvenile fines, they're capped in the code at 500, so you would never see more than 500 assessed in fines. When it comes to costs, we'd have to just look at the average, see if we could get to it.
Would also be nice to know sort of what types of cases are generating the bulk of it, or more than others, or whatever, just so we have an idea what we're dealing with.
Well, that's where we run into a challenge, Mr. Chairman, and as we worked with Katie throughout the summer, the issue is our financial accounting system sets up an account, it receives the payment, it credits it to the appropriate account and transmits it to the Department of Accounts, but the accounting system doesn't retain information about what the charge was. And so that's where we get into a challenge about trying to isolate the amounts that are affected by this bill, is that we can report on the total amounts collected in the JDR courts, but that's going to include case types that are not addressed in this bill.
Huh, okay. You could probably do a back of the envelope calculation based on the categories of convictions, I would think.
Correct. We could look at assessments and then apply that 60% collection
Okay.
rate assumption.
Got it. That'd be helpful. Thanks. Sorry to interrupt.
No, that was helpful. Thank you. So moving on to court-appointed counsel, just to highlight part of what the bill does. So currently, the state essentially fronts the money for court-appointed counsel, including public defenders, and non-indigent families are assessed back the amounts based on ability to pay. Those monies go to the general fund. So part of this bill is that any family using court-appointed counsel, regardless of their income level, the court could no longer assess those funds back. So just to kind of highlight that that's also part of what's going on with the general fund impact of this bill. Okay, so now moving on to amounts collected by other entities other than the court. So again, these are amounts that are not going to be included in that 360,000-ish that we just looked at. So Senate Bill 481 prohibits courts from imposing cost on juveniles, again, certain juveniles delinquents for the most part, which likely includes court-ordered services. There are several provisions in the bill that remove the court's authority. Some include evaluations, treatment, and education programs. Most of the provisions apply to juveniles in delinquency proceedings, but some apply to all children in the court's jurisdiction. We just discussed those are not going to be part of that 360,000. In general, the bill is not very prescriptive on kind of what happens when the court cannot impose those costs for court-ordered services. So the question really becomes, if the court can't impose the cost, what funding streams are available to pick up those costs? So again, while the bill doesn't really definitively lay out the process, I think we can look at what is currently happening for juveniles that are unable to pay and kind of assume that that might be what happens under the bill in terms of how this would play out and who would pick up those costs in lieu of juveniles. So the first category, and this is going to be the main category where juvenile delinquents are going to fall into. Essentially, if I'm a juvenile and I'm under DJJ court service unit supervision, DJJ is using its general fund appropriation as the payer of last resort for treatment evaluations and other services. That's going to include all services that are determined as being needed by the juvenile, including court-ordered services. And so basically the DJJ employees in the court services units first are going to draw from other funding sources, juveniles and their families' income itself, but also things like Medicaid, Family First, Children's Services Act, local funding sources, and then if they can't fund it with those, they're going to use their general fund appropriation. Right now, the general fund appropriation they're pulling from kind of comes in two categories. It's the Virginia Juvenile Crime Control Act funds, and also in some more limited cases, or actually some more expanded cases, sorry, that's the less used one. They also often use regional service coordination funds. Each of those in this past year, DJJ spent about $10.4 million. The idea is basically if DJJ's appropriation was picking up more of these costs in lieu of juveniles, that's going to increase the demand on DJJ's budget. Unfortunately, it's not possible to assess by how much because DJJ and the state is currently not tracking how much juveniles are paying. So basically, to the extent that that indeterminate amount that juveniles are paying is then picked up by DJJ, that's going to put pressure on their general fund budget. The other thing just to note is that it's currently DJJ policy that they cover those services with their budget. There is no statutory requirement in current law or under the bill that requires them to do that. So some of this would be subject to the appropriation, again, depending on the extent to which it's really a huge amount that they're taking on or a more minimal amount, maybe they could absorb it in their budget. And I'll pause there for questions before going to the next slide.
Do you have any sense whether any other states have this kind of policy? I'm sitting here looking at this thinking, like, the kinds of child that I represent in court, never indigent, because I don't do court-appointed work anymore, but I represent plenty of families who can afford to pay for all this stuff themselves, or if they were assessed it, they could afford to pay it on behalf of their child. So I'm trying to understand what the policy rationale would be if you have some families that have lots of money not making them pay. Do you have any idea what other states do on this, or whether anybody else has this blanket policy that juveniles never pay anything? Or
yeah, Mr. Chairman, I can skip it. We do get to that at the end. Do you want me to skip ahead or? Yeah, there's a slide on other states, so we have some research from Crime Commission. I guess in general, to summarize it, it's really a split, and it completely varies. So like some states, and you'll see this later on, but some states are really just getting at that first category. So they're only getting at courts, and they're only prohibiting courts assessed and collected by the courts. Sorry, costs assessed and collected by the courts. Some states are getting to this other category where they're just saying, okay, the juvenile is going to be mandated a court-ordered service, and the court cannot impose costs for that service. Some states do that, some states don't. So anyway, I think it's really split. And again, we'll have numbers in another slide in terms of how many states have passed this legislation. But even within those who passed that legislation, it's just really all over the map in terms of who is it applying to, what fines and fees is it applying to, and also how they're collecting it in that state. Like other states might not have such a variety of funding streams covering these services. So it's a little more straightforward because maybe the court's covering them and not all these different entities. So anyway, that's a long way of saying it varies, but there's a slide that quantifies that a little more.
All right. I think Pillion's the only one that still has school-aged children or juveniles. Let's make sure he pays if any of them have problems.
His kids are not going to have a problem. They don't behave.
So just noting some other impacts looking at the legislation. So as we discussed in the first slide, the bill prohibits support payments to the Department of Social Services from parents, guardians, and trustees of juveniles in delinquency proceedings that result in certain out-of-home placements. Essentially, we asked DSS to provide some estimates on what this would mean. This number you see here is really an upper bound. So DSS said that lost debt collections to the Commonwealth and localities would likely be less than $387,000 based on FY 2024 data. That's basically based on all DJJ cases in their foster care system. Obviously, delinquency cases are going to be less than that. We don't know how many, but it'll definitely be less than that amount. The other thing to note is that above amount doesn't include the impact on juvenile custodians who are currently receiving child support payments from parents of youth who are the subject of delinquency matters. So, say I'm in the custody of my aunt, my non-custodial parent was being assessed child support payments. In these kinds of cases, the bill would prohibit those collections from DSS.
So this genetic testing thing, I see that happen a lot in child support cases. Child support cases aren't included, right?
Child support cases, I think, would be under established child support obligations to support juvenile custodians.
So if somebody disputes the paternity and they demand a paternity test and it comes out that they're the father, they wouldn't be required to pay into this?
That is my understanding from DSS on how they would interpret the bill.
Okay, that's an interesting policy. Okay. Thanks.
So just noting a couple other things. There could be an impact on Children's Service Act parental co-payments. That's unclear for a reason I'll kind of explain more in another slide. I did just kind of look at the potential impact to alcohol safety action programs, since they're obviously a big referral piece. They're really rarely used for juveniles are really referred to that program, and often when they are, it's for underage DUI, which wouldn't be subject to this bill. So based on current program utilization, it's likely that the impact there wouldn't be significant. One thing I'll note is that we did focus on essentially the impact to juvenile delinquents, and the majority of the provisions in the bill do apply to criminal charges and delinquency matters. However, there are a couple provisions that enumerate specific things like evaluations by physicians, some other drug screenings that do apply to all children that are in the jurisdiction of the applicable court. So that is, I guess, not something that I chase down in terms of all those different cases and where all those funding streams are coming in. So that would be something that potentially further analysis would be needed to determine the additional impact. This presentation focused primarily on the juvenile delinquents, since that was the main focus of the bill with these exceptions. So then the last thing we'll kind of talk about on this kind of fiscal impact for courts collected or amounts collected by non-court entities is that, so there's no dedicated funding stream for court-ordered services available in the adult system. And I'll just note, this is probably unusual. It's not tracked. So this is based on anecdotal information from talking to state and local probation and pretrial agencies. But generally, even when juveniles are transferred to circuit court to be tried as an adult, they often continue to be supervised in the juvenile system. Just to kind of give you an order of magnitude, so in the last fiscal year, there were 191 transfer reports where essentially the juvenile court recommended it at least be examined whether the juvenile should be transferred to circuit court. So that's kind of way less than them probably were actually transferred to circuit court. And then a lot of those probably remained under court service unit jurisdiction, which means all the DJJ is that kind of pair of last resort. However, there are some juveniles who are supervised in the adult community supervision system. And essentially, there's just no dedicated funding available. It's really jurisdiction to jurisdiction. So I think an example that Fairfax highlighted was, say someone gets referred to sex offender treatment. In Fairfax, they have a contract where they can provide that at no cost if you're in JDR court, but not in circuit court. And really talking to a number of localities, it is piecemeal. Some localities can pick up that cost if the juvenile can't pay it. Some of them just really don't have the ability or their mechanism to do so. So for this group of juveniles, there really isn't a dedicated funding stream available in the adult system to kind of pick that up if the juvenile isn't able to pay. So now we're going to go just to Senator Cervello's question about other states. So like I said, they vary. So since 2018, 20 states have passed legislation eliminating some or all juvenile fines and fees. 10 states have introduced but not passed such legislation. That 20 states does include Virginia. Virginia passed legislation in 2021 that eliminated child support payments for juveniles placed in DJJ custody. So that's getting picked up in legislation that for states that eliminated some of juvenile fines and fees. And as I said, state approaches to prohibiting juvenile fines, fees, and costs vary. So in this, I kind of worked with the Juvenile Law Center, but according to them, some states' prohibitions only apply to juveniles being tried in juvenile courts. Some also do loop in juveniles being tried in adult courts, like Senate Bill 481 would do. Some states prohibit fines and fees that the court collects, while others prohibit all court-imposed costs. And then just in terms of how the legislation is structured, so some states enumerate the fines and fees being prohibited in addition to including a blanket prohibition. Senate Bill 481 mostly includes this blanket prohibition. And just speaking from kind of the perspective of assessing the fiscal impact, I think that's part of what made it a little bit difficult. So because basically the bill doesn't enumerate fines and fees, it makes it more difficult to comprehensively assess the fiscal impact of the bill. A good example of that is recovery courts. So under current law, recovery courts can assess payments from the participants for these services. Essentially, it would have to be determined whether kind of which part of the code trumped. So if this bill got adopted, does the JDR section of the code trump over the recovery court code section trump? And that would determine whether the recovery court was still able to collect these payments that they're currently authorized to accept. So really just key takeaways. So Senate Bill 481 would reduce court collections by an estimated $360,000 each year. We'll break that out on an average and try to do it by offense as requested by the subcommittee. In addition, depending on how the bill was interpreted and has been interpreted in some other states, the court may be prohibited from mandating services unless a funding source was identified. And we've kind of walked through what happens in terms of where the youth is, what that alternative funding source is. And then finally, and I think this was clear throughout the presentation, but systems limitations inhibit estimation and tracking of the bill's fiscal impact. We'll get some additional information kind of quantifying the amount of juveniles and the average fines and fees we're talking about to put it more in kind of a rough order of magnitude. But a lot of system limitations kind of, we're not tracking what juveniles are paying currently, so it's never going to be precise. With that, Mr. Chairman, that's the end of my presentation, but obviously happy to take any questions.
Correct. So just so I'm clear, if a juvenile is certified, tried as an adult, would this bill as written have affected those cases?
Mr. Chairman, yes. So basically, in the section of the code that gives the JDR court the power to transfer that juvenile, it essentially says that for those juveniles, except for the excluded offenses, the court may not impose cost fines and fees.
So you can be charged with murder, rape, child pornography manufacturing, you could be all kinds of stuff that we worry about, like gang crimes, things like that. They all wouldn't have to pay fines. If this had passed as draft.
Mr. Chairman, that is my interpretation, and Taylor's nodding as well.
Okay, got it. All right, thank you. That was very helpful information to have to evaluate this going forward.
So, Mr. Chairman, so the final presentation today is a discussion of the fiscal impacts collective bargaining legislation, if you recall, there were two bills in the Senate in this past session that came to Senate Finance and Appropriations and to the subcommittee. Both of those were left in the committee to kind of do some further research and to look at the fiscal impacts of those bills. So what I'll just do is quickly just kind of give you the background of where collective bargaining is, public employees of Virginia today, and then just kind of summarize the two bills and the fiscal impacts of the legislation, and then kind of just have some general implementation questions that in the future, if the General Assembly is looking at collective bargaining, especially when it comes to state employees, that some of the things that need to be taken into account. So as you all know, if you go back sort of in time, collective bargaining used to occur at the local level until a Supreme Court case in 1977. And then, of course, the General Assembly in 2020, you all passed legislation that allowed any county, city, or town, including local school boards, to implement collective bargaining by local ordinance or resolution. So it's basically a local option is what that does. It also established a process that in a locality that doesn't pass an ordinance or resolution, that if a majority of the public employees of a bargaining unit were to seek the collective bargaining, there's a process where the board is at least supposed to take a vote in that process. The current law still maintains the prohibition on public employees from striking. It doesn't technically require a locality to actually collectively bargain after they pass the ordinance. I do know that you'll see that I try to have a collective list in the next couple of slides. I know that, for example, that City of Portsmouth, I think, has passed an ordinance, but they have yet to implement it. So there's no timeline by which forces them to implement it after they pass the ordinance or resolution. Current law also provides that no adopted ordinance or resolution can restrict the governing bodies.
Mr. Chairman?
Senator Evan.
Could I just ask Mike the difference between, you said that they could adopt the ordinance but not implement it. Could you just explain that distinction?
Yeah, Mr. Chairman, Senator Evan. So I think what it is what the law basically says is you can adopt an ordinance or resolution that says that collective bargaining is allowed in the locality. But remember, once you do that, then you have to, there's steps that you have to go through to do that. You basically have to, the employees you have to select who their representatives for the bargaining. The local government actually has to then engage in collective bargaining, and that whole process, has to occur. It still requires the locality to initiate that process. So for some reason, they didn't want to do it right away. Maybe they had fiscal concerns or something like that, then they wouldn't have to do it right away. But they do have an ordinance or resolution that permits it.
Once they select, thank you, Mr. Chairman. So once they select a bargaining unit and have their first contract, then it would, from that point forward, be in place? I mean that they would have collective bargaining for that particular locality for that unit?
Mr. Chairman, Mr. Eben, that would be my understanding. But again, also the part that I was just mentioning too, that nothing in the ordinance resolution can restrict the public bodies from the appropriation of funds or establishing a budget. So if it really had an adverse fiscal impact, then that would sort of override, I think, that agreement.
Thank you.
And you recall that law took effect on May 1st of 2021. So the next two slides, this is the slide just for collective bargaining. Is to list those localities. I was attempting to put together a comprehensive list. If you're aware of a locality or a smaller city that has done this, I only listed it here if I was able to actually confirm and see their resolution or ordinance, confirm that through their website. So it's not always easy on every locality's website to do that. So, and I was putting the date here so that you would just have some timeline of, you can see that once the law took effect in May 1st of 2021, you can see the Northern Virginia localities were the ones that first got started, but it's gone to City of Richmond and Charlottesville and Portsmouth as well. And the next slide is the same thing with the school boards because they get to choose. And again, there are some smaller cities, I think even Northern Virginia, that might actually have it, but like I said, if I couldn't confirm it by seeing their ordinance or resolution, I didn't add it to this list. So if you're aware of one, just let me know and I can make sure I keep a comprehensive list of all localities or school boards that have adopted collective bargaining. So just moving on to the legislation 2024. So the first bill is Senate Bill 623 by the chair's bill, Senator Lucas. So this one was more narrowly drawn in the sense that it would authorize that firefighters and emergency medical service providers employed by any public subdivision of the Commonwealth could engage in collective bargaining. So where the big difference, where that would be with current law, is that this would make it this basically a bargaining unit, or if you if you separated them into 2 bargaining units, would be mandatory for all localities in the Commonwealth, assuming that they actually had firefighters or EMS personnel employed by the locality. And then, of course, it would allow collective bargaining regarding terms and conditions of employment, compensation hours, working conditions, retirement pensions, and other benefits. And retirement pensions, those things are an important thing to note because, you know, pensions are set out in statute. So, you know, I think VRS kind of sees it as that statute is what governs that. So, you know, in other states, they do allow negotiation of those things, but that's something just as a policy matter, you have to think about what is the scope of what you allow under collective bargaining going forward. The bill would have also established the Fire Service Corporation Board that would have 3 members, and it essentially would administer all the aspects and different provisions of the bill. That board actually would be a state board, and I'll talk about that in a second with the fiscal impact. And then, of course, when there's any dispute arising between the employer or the firefighters or EMS providers, then there's a provision for a 3-member board of arbitration to resolve such disputes. So look at the fiscal impact. So of course, we're talking about local government employees here, firefighters, EMS personnel. So the most direct impact is really on local governments that would stem from the collective bargaining agreements, whether that impacts increased wages or cost of benefits that they would really have to fund. Of course, and that would certainly vary by like how large the locality is, how many employees they have. Just to kind of give you an example of like under the current law, I use Alexandria because they were the first one really, that back in fiscal year 22, they had put $850,000 in their budget. And this is just the administrative side of kind of what you need to do. And just looking at Fairfax and some of the other localities that did it, it was all kind of in the same range administratively of what you sort of needed to have just as the structure to do collective bargaining under the current law. The Fire Service Cooperation Board created by the bill would also have Attorney General representation, so there would be a state cost of the bill, whether the AG's office would need another attorney, but there would also be the cost of staffing the board as well. So potentially, there was actually, interesting enough, there was no fiscal impact statement issued for this bill, but there's probably at least a state impact of a few $100,000, not knowing the scope of what they would have to do. Moving on to the other piece of legislation, Senate Bill 374. This was Senator Boysko's bill. So this one, very different, much broader. It repealed the current law related to collective bargaining and replaced it with collective bargaining, making it mandatory for all public employees with, of course, certain exceptions that were laid out in the bill. And that would also include state employees that allow them to collectively bargain. It also had a provision that would include individual providers, and in that case, what it's trying to get at are consumer-directed Medicaid personal care attendants, which sort of, or indirectly, sort of, you know, their wages are paid for by the state through the way that we handle that. The bill was very comprehensive. It included provisions related to prohibited conduct, the determination of the bargaining units, election of the bargaining representatives, how you conduct the union elections, and how do you resolve impasses as well. It designated that there would be 16 bargaining units for the executive branch, but since it, you know, that did not include the institutions of higher education, the independent agencies as well. So very likely the number of bargaining units, the fiscal impact statement had estimated there could be as many as 34 or more. The bill did maintain the prohibition of public employees from striking. And then one major piece of it was it established the Public Employees Relation Board with 3 members. That board would be a state board that oversees basically implementing all the provisions of the bill. So looking at the fiscal impact, since this bill and the fiscal impact is really focused on, of course, the board that would oversee collective bargaining throughout the state, but also for state employees. So most of these costs are focused on administering collective bargaining at the state level for state employees. The Department of Labor and Industries costs are essentially to support the board, the Public Employee Relations Board, the staff for that. The Department of Human Resource Management would need staff to kind of like to do the central labor relations kind of statewide. The Department of Accounts, the general fund was noted was $3.3 million. So if you looked at the fiscal impact statement, it talked about one of the costs being updating the state's cardinal human capital management system. If you remember, the Secretary of Finance talked a little bit about this morning. The total cost of that would be like $8.5 million, but basically they recover that money from the agency. So there's a non-general fund share and there's a state share. The state share is the 3.3 million. I do know that during the session, there was a concern by some of the proponents for the legislation that that seemed very high for a system. In my read of what's involved, I mean, it's an estimate. They would have to add an entirely new module to the system that would handle all labor management, all the bargaining units, that sort of stuff. So there's nothing that I've seen that's unreasonable, but certainly there would be systems changes that would occur. The Office of the Attorney General indicated that they would need 3 attorneys to kind of oversee collective bargaining from the state perspective. But the one thing to point out is that while these costs come up to $5.7 million the first year you did it, and $1.9 million the out years, it doesn't actually, the fiscal impact statement did not quantify the agency staffing costs. So for example, it referenced in Minnesota how basically even individual agencies have to have labor relations specialists within every agency. And in Minnesota, just as an example, they had like 150. So the fiscal impact statement only talked about having such positions. It didn't really quantify the total for statewide. So that's a piece of the fiscal impact statement that's not there. And certainly, of course, the collective bargaining agreements themselves, if they were to reduce, increase cost at all for the state, that's not technically factored in there either, as that would sort of be a future cost. So that kind of covers the 2 bills. Just to note, so since Senator Boyska's bill kind of focused on collective bargaining for state employees, if at some future point, if the bill comes back or the General Assembly continues to look at this from a fiscal impact standpoint, which is certainly the committee's focus, really I think some of the question comes into is how does the state incorporate any cost that result from the collective bargaining agreements and the biennial budget process. Certainly you would have to think about a process and a timeline for which collective bargaining agreements that information would inform the budget process of the General Assembly to make sure that you could fund it in the budget cycle of the Commonwealth. The other question would be, just like with current law, that it limits current resolutions and ordinances only to that which the local budget or the locality can appropriate. Would the General Assembly want to actually have a provision that says that collective bargaining agreements are limited basically to the funding appropriated as by the General Assembly? So different policy things to think about there. And again, like I said, so timeline is definitely, I think, something to think about for such agreements. And of course, and thinking about the fiscal impact, like I said, how much funding is required to make sure that you can adequately administer collective bargaining across all the impacted state agencies. And another major piece of that, like I said before, it's the scope of what a collective bargaining agreement covers. Is it limited to just compensation, benefits, working conditions, hours worked, that sort of thing? Should certain aspects of that be excluded or not? And then, of course, there are other questions about how many collective bargaining units do you want to establish? What employees are excluded from collective bargaining? You traditionally, of course, always exclude managerial and supervisory employees, but certainly there could be reasons that certain other groups would be excluded as well. And then making sure that the processes are fair for determining representation, as well as maintaining good faith negotiations between the parties and the ability to resolve any impasses in negotiations.
Mike?
Sure.
A couple questions.
Sure.
Where you are. I was actually in court last week, I think it was on Thursday, and a couple state troopers cornered me and were asking me why they were excluded from the bill. Do you have any recollection of that?
Mr. Chair, so yeah, like I said, and just talking about like what groups would be excluded, that was one of the groups excluded from the bill before that was in the session. I do not know the reason for that, but I can certainly inquire.
Yeah, I can too. Okay. State troopers are not some massive part of the workforce. What are they, like 2,500, 3,000 employees out of 230,000, something like that?
Yeah, the troopers themselves, I think, isn't it? I think the field positions is like 2,000, a little over 2,000 right now.
Out of 230,000, I think.
Yeah.
Total state employment is 230,000, is that right?
Total state employment is probably, I don't know, 140? About 140,000.
140,000. Got it. Thank you, Ms. Lawson. Okay. Mike, so you hit on one of the costs that was reflected in the FIS was the the need to program a new module for Cardinal. And I thought I was paying attention, maybe not close enough. Didn't we just get a presentation about the administration considering rebuilding Cardinal? So, I mean, couldn't that cost be consumed as part of any kind of Cardinal rebuild that takes place? That's something we would have spent anyway?
Yeah, so Mr. Chairman, yes, I mean, that they're looking at Cardinal modernization. Yes, that could certainly be part of them looking at that, but the question would then be, how does that align with if the General Assembly took action on this and this became law? The Cardinal project could be well over 5 to 8 years before they fully implement a whole new Cardinal modern. So you would have to align it with the timeline for a new system. So you
We
might
could
have
also prioritize building certain parts of it first, or at least building it to have the capacity to do it so that when and if the legislature chooses to do something, we don't get hit with a $5 or $8 million fist associated with that as well, right? If it doesn't marginally increase the cost of the Cardinal rebuild substantially, right?
Mr. Chairman, yes, that's definitely a possibility that if you plan it as to what you're doing, you might be able to find a way to keep that cost down.
Okay. Mike, I also saw in this fiscal impact statement, somebody, I guess it was DPB or somebody, said that there's a $60 million impact to the general fund because if we mandate all these localities to have collective bargaining, everybody's going to get a 1% raise, and then we're going to have to pay money because of it. Do you remember that part of the presentation? Or, I'm sorry, that part of the fiscal impact statement?
Yeah, so Mr. So I think what they were attempting to do was to say that if collective bargaining agreements required increase in wages or compensation or whatever, they were just showing like this is the 1% value of that for the state workforce, just to try to provide information. But again, it would be completely tied to the agreement.
Got it. But can we also agree that if all those people were to get a 1% pay increase, if they were, and that their unions didn't choose to focus on things like better health insurance or better working hours or other things besides just salary, they really went all in just on wages. If they did get that 1% salary increase, that there would also be a corresponding increase in the amount of income taxes collected by the Commonwealth to help cover that. So given that virtually every employee, not all, but virtually every one of them is paying income taxes at a marginal rate of 5.75%, about 5.75% or whatever that additional 1% would be would come back to the general fund as tax revenue in that same year, right?
Mr. Chairman, yes, depending on what tax year it accrued, but yes, it would come quickly.
Right, and that fiscal impact statement didn't include increased tax collections as an offset against this so-called expense they put in here, right?
Mr. Chairman, no, it did not.
Okay. All right. And did you talk to the Attorney General's office about exactly why they need 3 more people and why they can't, service these needs with existing resources in any way? Or that's just...
Mr. Chairman, no, I haven't spoken to him directly, but I can certainly ask that question.
Okay.
To get some more background.
Okay, Mike.
The only thing I was going to say is if you look at the presentation online, the last slide is just a couple links. If you wanted to look at NCSLs, they have a 50-state database of all union and collective bargaining legislation to see what other states are doing. National Council on Teacher Quality has a lot of information about collective bargaining laws from a teacher perspective, and just a couple of things there to try to if y'all want to look at something or if there's anything specifically you want me to bring back to you all, I can do that as well.
Mike, do you have any sense of where our state stands relative to other states? In other words, do you have any idea how many states have collective bargaining for state employees and or local government employees, mandated, right. Not optional, but mandated?
Mr. Chairman, I'll have to look at, I did attempt to try to put like a map in here to show you that, but as you can imagine, like collective bargaining laws are pretty complex about, in some cases they only mandate specific groups in states. Sometimes it's across the state. It kind of makes the map very colorful and to try to put them all into different categories, but I can certainly provide more information to the subcommittee about that.
Okay. Okay. All right. I know. I think Ms. Lawson's here from DHRM, right? Could you answer a couple questions for us too? Mind coming up? I asked you a bunch of questions last time about health insurance. I'm not. get some questions about this, 'cause I think thank you for coming. You're
Having me.
Yeah, you're primarily, I guess you would be sort of primarily in the vortex of this were it to be adopted. Is that a fair statement?
Yes, I believe so.
Okay. Did you all ever take a formal position on Senator Boysko's bill last time? I wasn't in the committee where it was heard primarily. It just came to my sub, and we dealt with it, I think, in about 2 minutes.
Senator Serval, yes, we did testify both to the Senate and the House bill that we opposed both bills, primarily due to the fiscal impact statement, which we were trying to be conservative and came up with about a $23 million implementation fee plus ongoing expenses over $30 million, based on conversations I'd had with other states that have similar setups. But also just due to the fact that we felt at this time collective bargaining at the state level was not needed. Our turnover is low, our grievances have been decreasing. We didn't see the need for collective bargaining at this time, especially due to the financial impact.
Okay, so that number you just threw out, are those numbers that are based on what's in the official FIS, or were there other numbers you're coming up with? Because I don't see numbers approaching that order of magnitude unless you're talking about the state share of the local pay increases.
So I believe, I'm sorry, Senator Serval, I believe the numbers were from what the FIS that DPB provided, specific to the state impact.
Okay, so I guess when you say those big numbers you threw out, part of that includes the state's share of a putative potential 1% pay increase by local governments and local school divisions that we'd be responsible for eventually.
Senator Serval, no. This was just at the impact to implementing collective bargaining within state government. It had no relevance on the localities.
Okay, so how did you get what did you say your number was, 30 million or 60 million?
So initial implementation cost of $23,957,940. I pulled this off of the website under for the bill for Senate Bill 374.
Yeah, that's what I'm looking at on my computer right now.
Okay.
So you say there's a $23 million fiscal impact on the state side for that?
Yes.
I see. Can you tell me what pages that appears on? Because I'm not seeing that when you add it all up. I see a lot of money for the 5 or 6 million or whatever for the computer module, and then some nits and nats here, but it doesn't get anywhere close to that number.
So, Senator Serval, I apologize. I just I just pulled up the bill, Senate Bill 374, and went to the final impact statement that was published. That's the only piece of information that I printed out.
Okay. Yeah, Senator Evans has a question while I try to get myself oriented.
Thank you. I wanted to know, do you think that state workers should be paid comparably to private sector workers in Virginia?
Senator Eben, I believe yes. If you look at the section of the code 2.2-1201, 1202, that's under DHRM, it tells us as an agency to provide and ensure competitive salaries. And we do a comparison every other year with both public and private sector employers.
So you would say then, thank you, Mr. Chairman. So you would say then that that the state workforce is paid comparably to the private sector at this point?
Senator Serval, Senator Eben, I would say on average, yes. When you look at, when we conduct our biennial compensation study, we find positions and employees that are paid above market, employees paid at market, and employees paid below market. And so we focus on those that are paid below market.
I see. Okay, and then, Mr. Chairman, a follow-up.
Go ahead, Senator Evans.
Our governor often talks about his business experience. I know the Carlisle Group, of which he was a part, owned a number of different enterprises. Some of the workers chose to be represented by unions, some did not. In either case, his firm was able to manage that workplace. And I'm just wondering, can't you manage, would he not be able to manage a unionized workforce of public workers if we did have unions?
Senator Eben, I don't know how to respond to that.
I'm saying if we passed legislation to have a union workforce in Virginia, would that be manageable?
We would make it manageable.
Thank you.
Okay, I think we figured it out, Ms. Lawson. I think, correct me if I'm wrong, but the fiscal impact statement lays out the fiscal impact in fiscal years 2024 through 2030 in a series of categories. And it appears to me you might be adding up all 7 years of impact as opposed to just 2 years, which is how we usually look at things. Do you think that might be what you were doing, or am I imagining things?
Senator Serval, I didn't believe that's what I was looking at, but I'm happy to go back and pull up on the website what I was reviewing and comparing it with what you have.
Okay. Huh? Yeah, okay, staff says they'll follow up with you on that. Okay. So, let me ask this. So is the administration's position that it opposes collective bargaining across the board or just for certain divisions? So for example, would they support it for the state police, do you know?
Senator Serval, I don't believe at this point there's any interest in collective bargaining at the state level.
Okay. One other question. So one of the concerns I've had since the pandemic happened is the amount of vacancies we've had within state employment. It's been nice in the sense that we have a lot of extra money to spend at the end of the year because of all these vacant positions. On the other hand, I worry about the level and quality of service that we're providing to taxpayers when we have so many vacancies. And talk about all the different causes of that, but it's my impression that collective bargaining has historically helped workers retain better pay and benefits, which results in higher retention rates. Does the administration share that view?
Senator Serval, I have not had those conversations with the administration.
Okay. Does the administration have any, I know Senator Eben asked you about pay gaps. Do you know if there's any kind of plan to address any pay gaps that exist between the private sector and the public sector by this administration?
Senator Serval, I'm unsure. I mean, the administration is relying on my agency to work with our consulting firm to review our positions that we believe are at or below market. So they're relying on us to provide that feedback. That may not be the answer. It's not a yes or no, but.
Okay. And do you think there's adequate systems in place right now? Or actually, let me put it this way. Can you describe to me what systems are in place right now to listen to employee concerns to make sure that they're being properly addressed if there's no collective bargaining?
Senator Serval, absolutely. So we encourage informal conversations at an agency level, staff meetings, things of that nature. If employees get to a point where they don't feel that they are being heard, we have our formal grievance procedure, which is utilized on a regular basis. We unfortunately do not see at the agency level how many grievances there may be. We get involved when a grievance is taken to the fourth step, which is at the hearing level, and then we assign a hearing officer. And I can say from 2016 when we started reporting out on the number of grievance hearings, that number has decreased from about 150, 160 to just over 100 in the past 8 years.
Yeah, I'm sure you can appreciate, though, there's a big difference between an individual complaining or issuing a grievance versus a group of people collectively articulating that they are unhappy as a group. And some people would say there's safety in numbers to complain as a group as opposed to complaining individually. Targeted, singled out, not promoted, whatever, that kind of thing could potentially happen. I mean, does the administration have any plan, or I'm sorry, does your division have any kind of system in place that allows employees to sort of collectively in the aggregate say that we as a group, we as a department, we in the office of blah, blah, together think we're not being treated well as a group?
So, Senator Serval, I would say we encourage employees at any level, individuals or groups, to express their concerns initially internally to their agency, their supervisor, their agency head. On rare occasion, if they don't feel heard, they can come to our agency. If we feel that there is perhaps a policy violation, we will investigate. We'll work with the agency to identify that level of concern. So I do feel there are avenues for our employees today to express their concerns.
Can you think of like situations? I haven't read anything about the newspapers, which would be the only way I find out about things. But have you told me there's been situations where like 30, 50, 100, 200 employees have come to DHRM as a group and said, we're unhappy about X, can you fix it?
Senator Serval, no, I have never heard of that many employees come. I have heard of a small unit in a facility that is concerned about perhaps management, and we'll go and talk with them and work with them and help them address those issues. Yes, but not hundreds or more.
Okay. Senator Evan has one more question. I don't think I have any others.
Do we have current turnover rates in our public sector workforce, including state workers, home care workers, and higher ed workers? Do we know how that turnover relates?
Senator Evan, you want, just to clarify, you want a total overall turnover or separated by type of employment or type of position?
Well, I mean, ideally by type of employment, but I'll take whatever you can give us.
We can certainly provide that for you.
Okay, yeah, I'd be interested in hearing about home care workers, higher ed, as well as the general state workforce.
Sorry,
Thank you.
I have one more question. Sorry, one more occurred to me when I was looking at the FIS. Thanks. I'm gonna take Pillion's question. Okay, Senator Pillion wants to know.
Very easy.
Okay. Senator McPike wants to know. Looking at the FIS here, it also talks about there's some public 16 institutions of higher education in the state. You know, that all those, there's a whole bunch of entities of state employees that you don't have any role or control over. Is that right?
Senator Serval, correct.
Okay, but your all's position, notwithstanding the fact that it doesn't involve your agency or the administration, really, it'd be independently managed by a board of visitors or whatever, some other place. The administration's position is the same with regard to those workers as well, and not just the workers that the state directly manages.
Senator Serval, I believe the answer is yes.
Okay. All right. I don't have any other questions. Pike? No? Okay. Ms. Lawson, thank you for coming again today. We appreciate it. I have some follow-up questions for you about health insurance we can talk about offline, but the things we talked about a month ago. Appreciate you coming today. Okay, I think that's it for our agenda, right?
Thank you.
That's it for our agenda. Thank you for coming today, everybody, and appreciate everybody's testimony and attendance.
The Senate of Virginia, Richmond, Virginia.